good afternoon, and welcome to Embargoed. Our episode today is going to feature a guest host, Tom Stocker, who is at Pinsent and Masons, working in export controls and sanctions and all things white-collar law, and he's out of the Edinburgh office in Scotland, but also works out of the London office as well. We're going to have a Russia-focused episode because that is the current times and the current hot topic in sanctions issues, and we hope to talk about a number of issues related to Russia. But we're going to start with the topic of multilateralism, and I have to say I wanted to start with this topic in part because I've never seen anything like it. I mean, and I think the main question that I have is whether it's the new normal. But before getting to that, I mean, I think we should just kind of lay out the case for it. What caused us to start thinking about this was the price caps, which we'll talk about, or the coming price caps, which we'll talk about later, which were completely coordinated among the allies. But generally, the Russia sanctions have been more coordinated than anything that I've ever seen when it comes to the energy sector, when it comes to the related export controls, when it comes to the financial sector that was targeted initially. There have been coordinated actions with respect to the accounting sector, with respect to quantum computing. And so I just want to throw it out there, Tom. Is this the new normal? And kind of where do you see this headed in terms of the coordination among allies on Russia sanctions policy?
Yeah, I agree with you. It's kind of unprecedented, isn't it? Because it used to be the case when we dealt with sanctions that they originated from the United Nations, so it was real proper multilateralism. That's now a thing of the past, and we're dealing with really the G7 nations plus the EU acting in concert and liaising very closely together. So yeah, I think it is the new normal. I think we are beginning to develop a new grouping of the G7 plus the EU that will probably in other areas of interest adopt a similar model going forward. I think that's probably most relevant to China if anything ever happens in that part of the world.
No, I think that's a great point with respect to China. And I think, one of the things that it's made this easier in terms of multilateralism is that the EU and the US and a lot of the kind of NATO countries, the NATO allies, have seemed aligned on this foreign policy. When it comes to China, the interests are a little bit different. But on the other hand, I mean, I think if you had asked people a year ago to talk about the possibility of multilateral sanctions kind of holding for the first 6 to 7 months with respect to Russia, there would have been a lot of talk about whether Germany was going to go along with this, and it did. So I guess that is it does remain a possibility even with a country like China, where there's not a lot of there's some consensus, but I think there's definitely some areas of disagreement between the U.S. and China.
Germany didn't just go along with it. Germany have exceeded all of my expectations. I would have said to you at the outset of this that the sanctions will be pretty limited because it's not in the European Union's interests, and the European Union has imposed sanctions that are far wider than the UK has imposed. So really significant packages of sanctions have been imposed at the EU level. We are beginning to see some dissent. So there's some dissenting voices coming out of Hungary, as you'll be aware, but also now Italy. But as a whole, they do seem to be holding the party line, and to say the sanctions that the EU has implemented in many ways are contrary to their national interests and have been really very significant.
Yeah, that's what's been really interesting to me is that Germany's economy, I mean, to oversimplify a bit, seems to have been built on the idea of cheap Russian oil. And so, having imposed sanctions in this area and seen the price go up, and the more the higher, the stronger the sanctions, the more the price could go up, although we'll talk about the price caps in a few minutes about whether or not they'll work. It would seem to be almost the thing that would be the most antithetical to the Germans to actually impose some really tough sanctions on Russia and have that consequence. But the Germans have held. I mean, is that, I guess, out, not only in the Russian context, do you see that holding, but more generally, I mean, one thing that I've noticed from from the outside is that both the UK and the EU have imposed sanctions and in a way that we haven't seen from over here. I mean, it really did seem before the Russia program that the US was the main sanctions enforcer in the world, and that the rest of the countries, while they would have sanctions sometimes that went along with the US sanctions, they weren't imposed nearly as aggressively, and they certainly weren't enforced as aggressively. And at least in my experience, overseas companies didn't take them as seriously when they were their own sanctions as they did with respect to US sanctions. But that has been completely different in my view with respect to the new Russia sanctions. I think that the enforcement climate and then the compliance climate overseas looks to me to be higher than I've ever seen, and I'm wondering if you think that'll last.
Yeah, I think it will last. Dealing with the UK, first of all, we're not the military might we once were, but we have a historical view of ourselves as having some global influence. And I think, as a matter of foreign policy, the politicians and the civil servants are keen on sanctions being used as a foreign policy tool, and for giving Britain a seat at the international table. And I think the EU are of a similar mindset. And as a result, we will continue to see sanctions being used as a foreign policy tool at an EU and a UK level. There's no doubt the UK Office of Financial Sanctions Implementation, OFSI, is modelling itself on OFAC. They want to have a regime that is similar to the US regime, so they're issuing FAQs, they're issuing general licenses. All of that is entirely new, and it is because they're looking across the Atlantic at how the US do sanctions and thinking that's how we should do it. So
yeah,
it's developing pretty quickly. I think the big interesting aspect will be enforcement. The reason often the EU blocking statute relative to Iran and Cuba frankly gets ignored by European and British companies is because they're absolutely terrified of US enforcement risk. And I don't consider at the moment companies are terrified of UK or European Union enforcement risk. That might change, but not currently.
Well, and I think that it's a progression. So, I mean, one of the things that I've seen, and it sounds like, this is happening in the UK as well, but I've seen it over in the EU and particularly in Germany. You have these enforcement agencies and you have the regulatory agencies now starting to issue guidance of the sort that OFAC has now been issuing for years. Although, I mean, when you look at the history of OFAC, it really didn't start until after September 11th in 2001. I mean, the agency was around, but the real enforcement and the real guidance and the real kind of professionalism of sanctions started then. And it seems like with the Russia sanctions, what you're starting to see is you have that same sort of thing that happened with respect to OFAC, about 20 years ago, is happening certainly in Germany, because my experience in Germany, particularly with the blocking statute that you mentioned, is that it just wasn't taken seriously at all. I mean, I had clients who would actually try to go in and get licenses to to violate the blocking statute, and were told by the German enforcers, why are you asking for a license? Just do what everybody else does and just kind of say you've got a business reason to ignore to stop your business in compliance with US sanctions and leave us alone. And now it seems like they're putting out guidance. Now, there's been some hiccups, as I understand it, because one day they'll put out guidance and then the next day they'll put out guidance that says the opposite thing and withdraw the last one. But I think that's to be expected. I mean, and so, I think we will, if the progression follows and the commitment is there, I think that we probably will start to see EU and UK regulators. Although to me, and let me ask this as a question, the UK seems a little bit ahead of the EU on this stuff. I mean, is that your sense?
Yes and no. So I think there are some EU. Remember, the EU issues legislation that applies to all member states, but the enforcement of it is a matter for the member states. So there's inconsistency amongst the different countries within the EU. With the UK, there is now a dedicated office within HM Treasury focused on sanctions, and they are undoubtedly wishing to increase their capacity. So they are recruiting at a significant level, and they're upskilling their existing staff. They're also engaging outside professionals to assist them with professionalising their operations. And they're doing some quite interesting things. So I think it's a matter of public record that Ofsted issued a tender to engage a forensic accountancy firm to conduct an investigation effectively into assets owned and controlled by something like 1,500 Russian nationals and businesses in the UK. And I think it was Ankura who secured the project. And you have to stop and say, well, why are they doing that? Why are they doing a significant exercise at significant cost to identify the assets of Russians living in the UK? And it must follow that it's because they're looking to, I think, probably firstly support the designations, because some of these designations are going to be challenged and are being challenged. But secondly, to start recovering assets in the UK. And I think that is an indicator that enforcement will follow, and it will be very much focused on Russia.
And in terms of asset recovery, how does that work in the UK? Is that Ofsey's responsibility, or is that something that another agency does? Because here in the US, OFAC blocks, but that doesn't get them the assets. It just freezes them. If you want to actually seize the assets, DOJ is actually the group that does that, and we have this like kleptocurrency task force or klepto task force that is going after oligarch assets, but it's in DOJ.
Yeah, it's the same in the UK. So it's the National Crime Agency have set up a dedicated task force. But interestingly, it's Ofsey who have engaged the forensic accountancy firm to undertake a review of the position. So they're clearly wanting to have a seat at the enforcement table. Although when it does come to enforcement, it gets passed to another agency.
And do those agencies historically coordinate? Because OFAC and DOJ, I think the coordination is sporadic at best, at least historically. How about OFSI and the National Crime Agency?
Well, it's all quite new. So OFSI have a civil enforcement power, and you can make a voluntary disclosure and enter into a civil penalty with them in lieu of being prosecuted for a criminal offence. And that's how most enforcement will be undertaken against British companies that breach the sanctions. When it comes to asset recovery or criminal prosecutions, then that will be passed to the NCA and ultimately the Crown Prosecution Service. My impression is that they are liaising very closely, and that there is a collective prioritisation of this as an area of enforcement. I still think any action that we'll see is probably going to be a year or 2 years away, inevitably, because these things have a long gestation period, as you know, Tim.
Yeah, no, I think that's the way that it's going to be here in the United States as well. I mean, we haven't seen a lot of the enforcement actions yet. I think that the task force here is trying to identify assets, trying to identify people who will cooperate with the task force in providing them information that could allow them to bring court actions that would result in the seizure of the assets. Because, from the perspective here, that OFAC's ability to actually block someone requires almost no process at all. So essentially, they block someone, and you can correct me if I'm wrong. My understanding is there is a pretty vibrant process that allows you to challenge designations in the UK and in the EU. People win those, at least from the outside. That's what it looks like. With OFAC, the process is much more truncated. I mean, you have to go to OFAC first. They can take months or even years just to look at your designation or your delisting petition, and they have some obligation to provide you the record of designation, but it's very minimal. And usually, when you go to OFAC to file the delisting petition and you ask for the record so you can supplement it, what you get back is something that will be so heavily redacted as to be pretty worthless. And so the OFAC process is not all that helpful. The court process has been not particularly helpful either, though better, because usually if the case goes to court, you'll start to get a little bit more of the record and find out actually the real reason for the designation. But the U.S. courts defer to OFAC's designation process so heavily as to make the challenge very difficult. It looks easier in the UK or the EU, but that might just be me seeing, the winning cases and not seeing all the losing ones.
Yeah, but there have been a number of successful challenges to designations. And it's partly because when these designations have been put in place, they've been rushed. And they're actually based on very little evidence. They're quite often based on public records, adverse media searches, rather than actual concrete evidence, which is possibly why we're seeing Ofsted undertaking this exercise, really to try and back up its position. But the courts aren't as sympathetic or as supportive. They will to the regulator. They will expect to see that the designation grounds have been met and that there is reasonable evidence to support a designation, and if there's not, it will be overturned. So we do see successful challenges through the UK courts and also the European courts.
And that's in the US. That's, I think, where the asset forfeiture and seizure process will come in. I mean, seizing the assets is not that hard. You can do it ex parte, but to actually forfeit the assets and get title to them requires a court case in which the government has the burden of proof. And so those are the sorts of cases. They don't get brought very much, quite frankly, because there's not a lot of asset forfeiture that's done or has been done historically with respect to sanctions issues. But when they do get brought, they're actually hard cases for the government to win if they're contested. And so I think we'll see, on your side of the Atlantic, it seems like there's actually due process in the designation and the challenging of the designation process. We don't see a lot of that on this side of the Atlantic, but what I expect we'll see, and we'll find out, is if some of these forfeitures are challenged, that there is a lot more process that is available in that area, and maybe we'll start to see decisions that look like the EU and UK decisions.
Yeah, we're going to see a lot of litigation around this because the value of the money and the assets that are at stake are really very significant.
Right. I mean, and that's really the what's happened in the US side is either there hasn't been a lot, the assets aren't all that significant, or when they are significant, there's really no obvious company or person that's going to show up to challenge them because there's not a lot of presence in the US. But I suspect that will be different for seizure of Russian assets in the UK, and may even be different for seizure of Russian assets in the US.
Yeah.
Well, let's talk a little bit now about price caps, because those are coming, and at the G7 finance ministers meeting in September 2nd, the G7 announced an intention to impose sanctions that would involve price caps on Russian oil. And on September 9th, OFAC came out with some preliminary guidance on what those caps would look like. And at least from the US side, it appears that the way that they're going to be enforced is there's going to be a ban on maritime services being provided in connection with Russian oil. So there'll be a general ban, but then there'll be a general license that allows those services to be provided if you can meet certain conditions. And basically that condition will be you'll have to be able to prove that the oil was purchased below a certain price, which remains to be set, and then you'll have some sort of compliance obligation to keep records of that and basically be able to prove it over the course of the next 5 years. So it looks like it's the devil is in the details in terms of what the price caps are going to be, and then the enforcement is going to be relatively tricky because it's going to create all sorts of record keeping burdens that may be tough to comply with. But that's what it looks like on the US side. I mean, from the UK and the EU side, Tom, I mean, what are you seeing on the price caps and what's being said over in the UK about them?
Yeah, the US is slightly ahead of us on this, Tim. So there was statements made after the 2nd September G7 meeting, but we've not seen any guidance issued from Ofsted or the European Commission. Interestingly, in this area, at an EU level, this will actually mean perhaps a reduction in sanctions, because the EU has a ban that comes into effect from the 5th of December relating to financial assistance, which would cover financing and insurance of Russian origin oil and petroleum products, including where the supply of those products is to third countries outside of the European Union. So I would anticipate the EU regulation is going to have to be amended to put in place this price cap mechanism. It will be quite a significant development from a UK perspective, and that's important because I think I'm right in saying that the UK remains one of the largest markets globally for insurance and reinsurance because of Lloyd's of London, very significant maritime shipping insurance market based in the UK. And under the UK sanctions, from 31st December, there is a ban on the provision of maritime insurance for oil imports into the UK, but it doesn't apply to third countries. So this price cap mechanism will, I think, be very significant. Now, as you say, the devil's in the detail. What's the price going to be? There is some indications that there might be multiple different levels of pricing, so it could be, like all of the sanctions issues, extremely complicated. And I think one of the big issues is going to be will countries who are at the moment importing oil from Russia get on board? I'm particularly thinking about the likes of India.
Okay. So, yeah, I mean, that's really so. What I was going to ask was a little more narrow, but I think let's go broader. So, from the EU, UK, and then even kind of India, China, I mean, what are the various competing considerations in terms of what the price cap should be? I mean, I think there's going to be some countries that are going to want the price cap to be extremely high because they want to import more oil, and they realize that if the price is low, there's probably not a lot of incentive for the Russians to sell it. Whereas there's going to be other countries that want the price cap to be extremely low because they're oil producers, and it'll be fine if Russian oil is essentially drying up because the price cap is so low, they'll be able to sell more of their own.
Mm-hmm.
I mean, so is there a kind of a united front on this? How is the EU breakdown on it? And then, countries like India, will they comply, and what do they think the cap ought to be, high or low?
Yeah, so I'm getting the impression there is a united front at a G7, so UK, US, and EU level. I think they've got to be really careful about unintended consequences, because I don't think anybody looking at the sanctions regimes can say it's been effective in terms of really harming the Russian economy while not harming our own economies. And I'm sure you've seen as well, Tim, with your clients, really quite significant harm to business and employers who one day were trading legitimately, and the next day they discovered their entire business model was unlawful. At the same time, Russia has continued to be able to sell its oil to China, India, and elsewhere. And this does seem to me to be a pretty novel approach. It's almost like US secondary sanctions in disguise being applied by the UK and the EU. So we don't have the concept of extraterritoriality in the way the US does, but here we're effectively saying that we are going to apply our sanctions outside of the UK and outside of the EU to third-party countries by blocking them effectively from the insurance market. I think that's a really significant development for the UK and the EU, and I do wonder if it will be challenged through the likes of the WTO.
Yeah, I mean, it seems like it is a big. I mean, it's kind of the American model of this. I mean, the U.S. Has a much broader view of extraterritoriality, and the way that it enforces it is, it's pretty easy for the U.S. with respect to U.S. nexus transactions. The EU has traditionally taken a much smaller view of this, but this is, to the extent that this is going to be a restriction, if the EU follows the same model and the UK follows the same model where there's a ban on related maritime services in connection with Russian oil, I mean, you're talking about transactions that almost inevitably will take place outside the territory of the EU and the UK,
Yeah.
by definition. And so it does look a lot like the secondary sanctions. I expect there probably would be a requirement here of a nexus. So, for example, if it's a but it'd be pretty easy to meet if you're talking about UK insurers, for example, and even beyond that. I mean, if the transaction, at least from the US model, if the transaction were in pounds or if it were in euros, that's probably going to be enough as well.
And the thing is, if you think about how the reinsurance market works, so you might be able to insure through an insurer based outside of the US or the UK and the EU, but you'll want to reinsure that contract. So and that will inevitably bring in place insurers within our jurisdictions. So I think it could have a very significant impact on international oil trade. And then there'll be a big issue about circumvention and Russian oil going through third countries. So yeah, I think it's going to be big. I think they are blazing in terms of the kind of the escalation of sanctions. This seems to be it. This is where they're going to go, and maybe it's a model that they'll use in other areas.
Yeah, it seems very targeted. I mean, but we'll find out if it'll work, because it seems like they want to have their cake and eat it too, right? I mean, they want to sanction Russian oil without driving the price up of oil generally, and Russian oil in particular. I think that is really the model of the future if it works. But boy, I see some real problems with respect to the price setting, problems with respect to compliance, problems and the compliance issues. From the U.S. side, the compliance issues I think are pretty straightforward, because it's just going to be a matter of, do companies think that the record keeping process is worth it? It's something that they've seen before. They'll probably be able to figure out the compliance issues and make a call on that. I think for companies that aren't used to kind of extraterritorial sanctions generally, so like a UK company that's not used to dealing with UK extraterritorial sanctions, I think there's going to be another part to that process where they actually have to have a learning curve just to realize all of the sets of circumstances in which these sanctions could originally apply, and then figure out whether or not they're going to have to, whether they want to actually go through the compliance burden. But kind of the issue spotting up front is a little bit different, because US companies are used to that, but and to be fair, non-US companies are used to that with respect to US sanctions, but I don't think they're used to actually trying to anticipate extraterritorial effects with respect to UK or EU sanctions, and we'll see how that plays out. But I think it's going to be a compliance nightmare.
Well, and I think you hit the nail on the head, and this is something that the regulators don't yet understand. That unlike Iran, which was nice and simple, the Russian sanctions are so multi-layered, and there are nuanced differences between the positions of the UK, the US, and the EU that creates real complexity and uncertainty. That many companies, I think, will say, unless this development is kept really simple, I think many companies will say, look, this is just too complex. It is unnavigable. We cannot figure out with confidence how to comply with this.
Yeah.
So you might find gold plating in the market effectively drying up.
And how confident are we that this is all going to get done and kind of agreed to by December 5th? I mean, they've really set a line in the sand with respect to December 5th. It's the day that the U.S. general license with respect to Russian energy expires, and I think this new regime is supposed to take place. But I mean, we're now at September 23rd when we're recording this. December 5th is coming up pretty fast, and they haven't even agreed to what the price caps are going to be. And as we've discussed, that's going to be pretty complicated. And then once you do that, I mean, how do you get the OFAC document is about 8 pages, but there's still a lot of questions that I had after reading it, and that's not much time to hammer out those questions here in the U.S., much less in the EU and the UK.
Yeah, I think they will hit the deadline. I mean, they might be a few days late, but they'll be there or thereabouts. There is a really unfortunate practice developing of issuing law that's not complete. or hasn't been fully thought through. And then the guidance that is there to build upon and explain the law, it doesn't come out for 6, 7, 8 weeks.
Yeah, and to be fair, I know that they've been thinking about this a lot longer than the announcement. I mean, I was talking to folks from OFAC over the summer, and they were already kind of working on price caps and kind of letting people know that price caps were coming. So it is something that they are not just, that they have been thinking about longer than just September. But I still think that the difficulty is going to be thinking through what you said, the unintended consequences, and then also coming to an agreement on what the cap is going to look like, because there's so many competing interests here. I mean, as you said, the much of the EU and the UK are not importing Russian oil at this point, and so in the U.S. we have an oil import ban, and the guidance on the caps was very clear that that's not going to change the import ban. And so, it's one thing to impose these price caps from the U.S. side when you're not even going to import the oil at all. It's another thing when this is actually an important part of your economy. And I think there's a lot to hash out with respect to that price, because it's not just a matter of picking a number.
Yeah, and you have to be careful that what you don't do is lead to the development of an entirely new insurance market for the non-G7 nations of the world. And we've seen that a little bit with the Mir payment system that's been developed in Russia as an alternative to Visa and MasterCard, and the Gulf states, Turkey have been supporting that. You have China looking to move away from US dollar trade. If we end up in a situation where we're encouraging a really a new insurance market, I'm not sure in the longer term that's necessarily a positive development.
No, it's a great point, and it's what we've been talking about for years over in the U.S. is kind of when does the rest of the world reach the limit? The U.S. is basically the entire sanctions policy of the U.S. is driven by the idea that cutting companies off from the U.S. dollar and the U.S. financial system is such a strong hammer that they'll be able to enforce these sanctions, and it won't essentially dry up the market for U.S. dollars. But at some point, and I think we've started to see it with respect to Iran and as you mentioned, even with respect to Russia, where they're creating their own financial system and trying to link it up with China, we might have reached that point with the U.S. financial system. If you start trying to use the U.K. insurance system, the U.K. insurance system is the same sort of tool, do you get to the point where China and Russia decide, hey, there's a market here for shipping insurance that the UK can't meet because of the sanctions?
Yeah, so, I think that's the risk. So, I'm afraid I don't have anything I can tell you as to where the UK or the EU are on the price cap. We haven't had the same guidance that's been issued by OFAC, and hopefully it will follow in the next couple of weeks.
Great. Well, why don't we turn to the last main topic here, and that is quantum computing. So at around the same time that the price caps came out, the U.S. came out with two new announcements with respect to quantum computing. The first was that they targeted the quantum computing sector as a sector that is now subject to U.S. sectoral sanctions, the way that Executive Order 14024 is phrased. The Secretary of the Treasury can designate certain sectors that become subject of the Russian economy that can become subject to sanctions, and now the quantum computing sector is subject to sanctions. And in the same way, there's another executive order, 14071, that allows the Secretary of the Treasury to designate sectors that are subject to special U.S. export controls. And so now the quantum computing sector is going to be subject to special U.S. export controls as well, or heightened export controls. There's basically a licensing requirement that didn't exist before. And so basically what is going on here is really kind of my question. And I have some thoughts, but I'm anxious to hear yours first.
Yeah. This might be an area where the UK and the EU are actually slightly ahead of the US, possibly. I think it was back in April that the quantum computing component software technology was added to the UK prohibited list of exports. Likewise, the EU has prohibited the export of quantum computing software and components since I think it was the 8th of April. We also have a prohibition on related technical assistance, financial assistance, and brokering, so arranging trades in those goods and services where the destination is Russia. And there's a more general dual-use ban applicable to the Russian Quantum Center, so the International Center for Quantum Optics and Technologies. That's been in place since April. So the actual trade restrictions that have been put in place by the UK and the EU, I think, are perhaps underappreciated. They are very, very extensive. It's a long list of goods that cannot be exported to Russia. And if the item is on the export control banned list, then you also can't provide technical services or financing related to that trade. So it is already, I think, quite significant, and I think what we're beginning to see is two things. They're looking now at what else can they ban, because there is such an extensive list already in place. And secondly, we're seeing a real tightening of the licensing regime. So up until this month, we were seeing licenses being granted for Russian trade. So dual-use equipment, yes, you would get a license if you had a pre-existing contract. You could bring yourself within one of the licensing grounds. We're now seeing the licensing authorities exercising their discretion to not grant a license. And in some cases, the reason for it is because it could further the Russian military, and these are fairly anodyne dual-use items. They're really nothing to get that really, on a proper fair analysis could enhance the Russian military. So there's definitely a tightening of the licensing policy, and it's far harder to get a license for this sort of stuff these days.
Yeah, I mean, that's one of the, we haven't seen it yet with the quantum computing issue, but that is one of the things generally in terms of licensing and in terms of just general both sanctions and export control policy is that Russia is being treated a lot more like, from the U.S. perspective, say Iran, where the answer is presumptively going to be no. I mean, that's the legal standard, but as a practical matter, it's going to be no, even if you can make arguments that seem like they ought to overcome the presumption of denial. So that's probably what we have to look forward on the quantum computing side. So with that, we'll go to the lightning round and talk about some of our final topics. But and why don't we start first with the Russian countermeasures. So we've talked about kind of what what we're doing in the U.S. and in the U.K. and in the EU. What's going on? What are you seeing in Russia with respect to the Russian government and how it's treating Western companies that are doing business there?
Well, most of the Western companies that we're advising are no longer doing business in Russia, or they're trying to exit that business. The main Russian countermeasure that we've seen relates to the Sakhalin oil fields. Yep. So they effectively nationalised the joint venture entity, and they've issued Novation agreements to all of the suppliers to novate the contract from the JV entity over to this new entity that they've formed. Now, as a matter of law, you can't force somebody to novate an agreement. Obviously under English law you can. It has to be a consensual task. But if you don't enter into that novation agreement, you can pretty much write off your ability to get paid for your goods or services that you've already supplied. So I think we're going to see more and more entities being effectively nationalised and run by the government of Russia. And then with them seeking to then novate contracts.
Yeah, I mean, so what I've seen from the U.S. side with Sakhalin, I agree. It is kind of you can't leave even if you want to leave, or if you do, we're basically just going to take it so you can leave, but you can't leave with your property. But it's even apart from that, over the last 6 months, I mean, one of the things that I think is really unusual compared to some of the other sanctions regimes that I've seen and kind of seen as companies have exited is just how difficult not only the Russian government, but the sanctions generally have made it to get out.
Yeah.
So, in my experience, I've had clients who want to leave, um, in large part because it's become impossible to do a compliant business in Russia, because the financial challenges are extreme. And what we're seeing here is that the U.S. companies that have subsidiaries in Russia, those subsidiaries are being forced to essentially take payments from sanctioned banks
Yeah.
or make payments through sanctioned banks in a way that you can't. If you want to stay, you've basically got to stay if you've got a U.S. presence by violating the law, which companies aren't excited to do, so they're trying to get out. But getting out has proved extremely difficult because not only the Novation is the kind of extreme version of it, but when companies that I've represented have tried to sell businesses, they've basically, you've got to get licenses, and then you go to the Russian government and they impose so many conditions, including, I had one client that was told that if they wanted to sell, they had to sell to this person, and when they figured out who this person was, it turned out to be Putin's nephew.
Yeah.
And so it's and then from the export controls are such that because the U.S. has so many export controls and they apply to transfers in country, if you actually sell to a Russian business, that is counted as a transfer. So you've got to look at every item in your shop that is subject to the EAR, and if it has a licensing requirement, you've either got to get a license, which I haven't had a client try to do that yet, or the thing that I've now advised on multiple occasions is you take the sledgehammer approach, because basically the BIS here has guidance that says that if an item is classified as some sort of thing on the Commerce Control List with an ECCN, but if it's disabled, it becomes EAR 99. And so and since there's no licensing requirement for most EAR 99 goods, if you disable it by taking a sledgehammer to it and breaking it so that it's not functional, so that it's not part of the transfer, you can actually avoid those licensing requirements. But it's felt crazy to me to say, my considered legal advice is take a sledgehammer to your computer router so that you don't have to transfer it along with the sale, because if you don't, then this is potentially a transfer that would require a license. So it's just gotten, the Russian countermeasures have made it really difficult to stay, but I've never seen it so difficult to leave. Like the period that's kind of most recent for me was the Iran period, when the U.S. withdrew from the JCPOA and companies were leaving Iran. It didn't seem that hard to leave. There were some issues and sometimes some contractual issues, but nobody was kind of told, you can't leave or we'll take your property. At least I didn't have any clients in that position. In Russia, it seems like that's where everybody is.
Yeah, no, I agree. And I think there's two issues. There is the countermeasures the Russian government is taking, and then there's the fact that the wind down periods certainly under the UK licenses are just far too short.
Yeah.
You're given 21 days to wind down a substantive transactions, and in the real world it just isn't enough time.
Yeah, that's what, and we had the same thing on the U.S. side. That some of the wind down periods were as short as like a week. I'm not sure what you can do in a week. Unless you're actually kind of monitoring the OFAC email list or monitoring their website. A lot of clients aren't even finding out about the wind down periods before they've expired.
Yeah,
So.
Absolutely. Can I ask you, Tim, about
U.S.
secondary sanctions? Because they were really an effective tool when it came to Iran. We over on the side of the Atlantic were terrified of them. With Russia, as I understand it, there are U.S. secondary sanctions available. Are they being utilized, and do you think there is a risk of them being utilized?
So this, I think, kind of turns back to the first topic with respect to multilateralism. I've thought from reading the tea leaves that the deal that the Biden administration struck with the NATO allies has been, which, our secondary sanctions are very unpopular in most of the rest of the world, because they essentially by definition say here are some transactions that we have no interest in and no jurisdiction to regulate, and we're going to go basically regulate them anyway. And I think that the bargaining chip that the Biden administration spent on the multilateralism was essentially telling the other countries, if you do your job, we're going to stay out of your business. We're not going to be imposing secondary sanctions. And one of the things that's really interesting is that the main form of secondary sanctions on Russia is this CATSA law, the one that was passed in 2017, that actually has some very broad language, and it's mandatory that the administration shall impose sanctions upon parties that are subject to sanctions that target the Russian Federation. I mean, I'm paraphrasing, but it's that broad. It's basically anybody who's sanctioned under laws or sanctions that apply to the Russian Federation. The administration has not used CATSA as an authority for any of the executive orders that have come out in connection with the new Russia sanctions, and has given guidance that suggests that CATSA is really not an authority that they're relying on, and that they do not consider parties that are sanctioned under these Russian sanctions as subject to these secondary sanctions provisions of CATSA, and they haven't shown any real appetite for imposing secondary sanctions. I still have some questions about whether they can do that, given that it's congressional language that is so broad and pretty clearly what should include sanctioned parties. But at least for now, all the signals that we're seeing is that they are not imposing sanctions for transactions that don't involve U.S. persons or some sort of U.S. nexus.
Okay, it's good. It's good to know. The reason I asked that is that one of the things we've seen with the 50% rule. So your 50% rule applies at 50%. Our 50% rule is actually more than 50%, and we do sometimes see a situation where there's normally a company that's subject to the sectoral sanctions that would be caught by the US 50% rule, but is not caught as a result of their shareholding being right at 50% and not more than.
Interesting. Yeah, and so I would think in those circumstances, if you have obviously if there's a U.S. nexus transaction, you're going to have to abide by the U.S. rule. But if there's no U.S. nexus, I think the risk of secondary sanctions would be extremely small, if not zero, because I think the risk of secondary sanctions right now for these new Russia sanctions in general is pretty small. We haven't seen it, and the administration has not made much noise about it, and OFAC has not made much noise about it. Now, when if you look at their guidance, it does point out that these executive orders have material, financial, and technological support provisions that are in most of these executive orders, and they apply to any person. So any person who provides support to a designated party is subject to these provisions and could be subject to designation themselves. And since that could apply to a non-U.S. nexus transaction, and occasionally has been, that's a form of secondary sanction, but not the form where, in CATSA 228, for example, where there is a provision that says anyone who does who engages in a significant transaction with a sanctioned Russian party shall be sanctioned themselves. It's more, the material support provision is a lot more mushy and a lot less mandatory. But on the other hand, OFAC has some guidance that suggests that it could apply. So it's not fair to say there are no secondary sanctions, but the guidance suggests, and the practice so far has suggested, that that's really not what the U.S. is in the business of doing. All right. Well, why don't we turn to the last two segments where we're going to make some predictions, and I think we've touched upon this already. I mean, I think you've predicted now, you're on record now suggesting that December 5th is really when these price caps are going to go into place, and I think that sounds about right. I mean, do you have any predictions beyond that in terms of where these energy sanctions might go beyond price caps, or do you think price caps is really what we're going to see for the next 6 months in the energy sector?
Yeah, it feels to me that it's the price caps is the last role of the energy sector sanctions. I mean, where else do they go? Right. It would become almost a complete embargo, which I just don't see that there's any political appetite for a complete oil and gas embargo against Russia because of what it would do to the cost of oil.
Yeah, I mean, I that's really the question in my mind is, the price caps are going to come and they're going to be complicated, and we'll see if they work. If they don't work, what's left? And I think embargo is the only thing left after the price caps come. And I think, we'll see in probably 6 months to a year if the price caps don't work, and if, God forbid, the war is still going on, whether or not there's appetite for a complete embargo, because that is the only thing that's really left. And it's
Yeah.
been, there's certainly countries that have called for that. But I think that would be a real test to the multilateral approach if embargo of Russian energy was on the table.
Yeah, I just don't think it's practically it can be done. I don't think the European Union, despite all of their efforts to store more, are in a position where they could cut that supply off. Now, if it gets cut off itself,
Right.
that's a different matter.
Well, and what about, and I just don't know the numbers on this, but what about if at the same time that the embargo went into place, the secondary sanctions and the primary sanctions were lifted against Iran and Venezuela, because that could put a lot more oil back into the market. I mean, it looked for a while like that's what the Biden administration was working towards. There's still, at least as I understand it, active negotiations with Venezuela about lifting at least some of the sanctions on the oil sector. And the JCPOA, we for a while, Brian and I were doing segments almost every 2 weeks that talked about the JCPOA, and it was still dead, and it still seems to be dead, but there's always this talk of reviving it. And I think, that if that were to happen, that, to me anyway, would at least marginally make an embargo more likely, because just the supply would go up, but maybe it's not enough oil.
No, I agree with you. I just don't see it happen. I think there might have been a prediction at one point on embargo that it might happen, but I think the problem, as I understand it, is that Iran is no longer adhering to the terms of the agreement, and as such, I can't see that it, unless there's a complete sea change, I can't see it happening.
Well, and the time is so short. I mean, Iran, apart from not adhering, which has also made it a deal impossible, Iran understandably wanted something that I think the U.S. can't really give them, which is some sort of guarantee that the U.S. won't back out again.
Yeah.
And at this point, with the U.S. presidential elections only about 2 years away, getting back into the nuclear deal, which would require actually probably a lot more implementation time for Iran, since they are a lot closer to, a nuclear weapon, as I understand it. So they'd have a lot more to do to disable that capability and then verify it. It just seems like we're out of time, in my view. I can't imagine entering into a new JCPOA a year before the U.S. presidential elections and then potentially having the U.S. back out almost as soon as it's implemented.
Yeah.
Finally, financial institution sanctions. I mean, they're already pretty strict with respect to Russia. Do you see them going anywhere from here? I mean, there's still plenty of Russian banks that aren't on the SDN list, but it seems like there's so many major players in the disabling of the SWIFT system with respect to those banks. I have a hard time seeing further sanctions on this, but if we do go towards a full embargo, you could see going down that road.
Yeah, it's really interesting. I think the ban on SWIFT was significant, but there's an awful lot of Russian banks. There are also European banks in Moscow who are operating quite freely. It's actually fairly easy to get paid in and out of Russia through the banking system.
Yeah.
So I would have thought if there is going to be a tightening, that's where it might be. There'll be more banks added to the list, and more entities added to the list. I think we're going to get to a stage where it's just more designations, more listings to slowly make it more difficult.
Yeah, no, I think that sounds right to me as well, because I agree with you. It is, having seen kind of how the financial system sanctions and just in practice work with respect to Iran, the difference between trying to do banking in and out of Iran and trying to do banking in and out of Russia is like night and day, even though we have, what everybody would agree is the toughest part of these sanctions are targeting the Russian financial sector. But there's so many banks that aren't on the SDN list, and there's so many banks that, that you're still allowed to do business with, that it isn't you have to be more careful with Russia now because you have to actually map out your payment chain so that you don't inadvertently get something blocked. But it's not that hard to do, and
Yeah.
it is with Iran. It's basically impossible.
Yeah.
So, but we'll see. Well, thank you for coming on the show, Tom. I think this was your second time, and it's great to have you back. And if you've got any final comments, we will be glad to hear them, and then we'll look forward to the next time we talk.
Well, it's a pleasure. Thank you for getting me back on Embargoed. I do love listening to your show. I think keep an eye out for enforcement and asset seizures. There was a raid a couple of days ago in Germany across several cities targeting Mr. Usmanov's properties and assets. And I think we're going to see more activity like that in the UK and Germany.
Agree. Enforcement is coming.
Yeah.
Thanks for listening, everybody, and stay sanctions free.
Indeed.
Produced by Heartcast Media.